लाइव तो हूँ. या गूगल इस पे कर ले मीट पे. लाइट कम है यहाँ पे. आई एम लाइव. कोई है ही नहीं, अभी एक ही बंदा है. एक ही है सिर्फ. Am I audible? Hello. Just give a thumbs up in the chat section whether I'm audible to you or not. Okay. So before moving ahead, just we will do a recap in a moment. Right? Okay, cool. Thank you so much. Today's session is about reading of Bear Act. First, now why do we need read Bear Act? We read Bear Act to understand what what are the intentions of a parliament or the legislature for drafting a particular Bear Act. First thing. Second thing, cool. Second thing, what are the things that we get to know after reading a Bear Act? First of all, its purpose. Second, what are the issues that it is addressing, or what are the remedies that it is giving to our client? Third thing, what are the essentials that we need to keep in mind while drafting our plaint, complaint, or any of the pleadings? I'll give you an example. Let's say section 138. How many of you know 138 of Negotiable Instrument Act? Section 138. Guys, you need to be responsive through raise of your hand in a chat box. How many of you knew what are the essentials of a 138 that we need to? Cool. Or how many of you know what are the essentials of a valid contract? Good. So why do we read Bear Acts? We read Bear Act to understand the intent of a legislature. Uh, Very good, Shakti. Second, to know what are the remedies that it gonna provide. Third, what are the essentials that we need to keep in mind while drafting a pleading. So let's say, what are the essentials of a valid contract? Anyone would say it's an agreement, competence of a party. What are the else? Agreement. There has to be an agreement, competence of a party, as lawful object, lawful consideration. What else we are missing? Anyone? What else we are missing? Agreement has three aspects: offer, uh, offer, acceptance, and consideration. Absolutely, actually. Further, other criteria are competence of a party, that they should be of sound mind, they should be a major, they should be major, um, they should be solvent. These are the then there has to be consent. Which kind of a consent? Free consent. Exactly, free consent. The contract has to, all these criteria makes a valid contract. So if we break down these 5 to 6 aspects of a valid contract, it will totally, it will go into like 9 to 10 essentials of a valid contract. And then while drafting a valid contract or while drafting a pleading, we must address all of this. That there was an offer from A, acceptance was a B, consideration was A will give 100 rupees in return of the and B will give 10 pen of 10 rupees each. Other aspect would be uh, the consideration was lawful, and there was uh, it was done in the free consent, both the parties were major. So if we address all of these issues, and the issue, let's say, you you are the minor and I'm the major, it becomes a void contract. Then this is the issue. You, while drafting the pleading, then you address this issue, that this is an issue, these are the precedent, and this is what I am seeking. Either I am seeking annulment of the contract, or I am seeking the damages for the contract. So how do we know that these are the essential that we need to consider? We know it by reading a bare act. I'll I'll take the example of section 138 of the Negotiable Instrument Act and how to read it. So as all of you know that section 138 is used for bouncing of check. This is what you have known from your um, day-to-day experiences, or you have heard it, your senior talking about, your parents talking about, that I have given check and it shouldn't be bounced. They use the term bounce, but actually, does this act cover any of the term called bounce? Answer. Do anyone know? Does this act define any term named bouncing of a check? Yes, no, maybe. Let's figure it out. So that's the rule one of reading a bare act. If you are reading it for a first time, no sir, no. Start with the introduction of a act, or the synopsis of an act, or the objective of an act. It will, exactly, there is no such term defined in negotiable instrument or any of the general clauses act, or the any act called bouncing of a check or bouncing of a negotiable instrument. It's a term used in a common parlance. So how do we know that? We know it by interpreting this act. So after going through the introduction part, the preamble part, you have the fair amount of gist. Key what this act gonna cover? What are the remedies? Who are the authorities? And in which year the particular act was drafted? After that, roughly you skim through the index. Why we need to skim through the index instead of directly going to the section? Because the entire act, be it this act, be it Indian Contract Act, or take any of the act, all of the acts are divided into chapters, and every chapter talks about one particular aspect of an act. For example, uh, modern days law after independence, whatever the acts have been drafted, it start with preliminary. Chapter preliminary means it gives you a gist. What are uh, the preliminary will include short title, what this act is called, where it, in which scenario it is applicable, and certain interpretation clauses. Chapter 2, a chapter, here it is, it is talking about notes, bills, and checks. Generally, chapter 2 covers all your interpretation clauses. So, chapter 1 is a preliminary chapter, and chapter 2 is your interpretation clauses in majority of the sense. So, different chapter covers different heading. Here, the chapter number 3 talks about parties. Chapter Chapter number 4 talks about negotiation, why we are entering into or using these instruments. Chapter 5 talks about presentation. So, all these chapters from starting, they are addressing a problem or the process from the inception to its end. So, but we are taking example of 138 to understand the interpretation. So, interpretation, section 138 is covered under chapter 17th of the Act. And so after understanding which chapter governs that particular section, then you read the chapter heading. The chapter heading of chapter 17 heading is of penalties in case of dishonor of certain checks for insufficiency of fund in the account. So हमने चैप्टर पढ़ा, समझ लिया कि ये चैप्टर के अंदर ये मुद्दे कवर हो गए. कौन सा मुद्दा कवर होगा? डिसऑनरमेंट ऑफ चेक. Which? Dishonorment of check. Only it's talk about dishonorment of check. Now, after reading this chapter title, you go to that section. So, first rule is read the introduction and the preamble. Second rule is read the chapter heading. Second rule is read the subheading or that section heading. So, if you're gonna read, all of you please open the Negotiable Instrument Act in your laptop and follow with me. Now I am reading subheading of section 38. It talks about dishonor of check for insufficiency of fund, etc. in the account. Now, if you break down this particular subheading of section 138, it talks about it addresses four things. First, it talks about dishonorment of what? Checks for insufficiency of funds or any other means. Where? In the account. Account of whom? Of which is maintained by us. So we are clear. These are the primary targets that this section 138 will address. So we are done with rule 3. Now the rule 4 of reading a Bare Act is you read a Bare Act like you read a novel, just to understand a fair overview. For example, I'll give you a demo where any check drawn by a person on account maintained by him with a banker for payment of any amount of money to another person from out of that bank for discharge in whole or in part of any debt or other liability is written by bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to the insufficient to honor the check, or that it exceed the amount arranged to be paid from the account by an arrangement made with the bank. Such person shall be deemed to have committed an offence and shall, without prejudice to any other provisions of this act, be punished with imprisonment or with a fine which may extend to the twice the amount of check or with both. Now, after this reading this act in a one go, I understand it. There are. It is talking about 2 to 3 aspects. One is talking about there is a party who is present giving a check drawn on the bank for uh, to clear the debt on any other liability. But this is not clear due to insufficiency of fund, and इसमें नहीं हुआ, then there is a punishment. Punishment can be of imprisonment of up to 1 year, uh, fine up to the double the amount of the check, or both. But have I cleared every other thing? Have I understood every aspect of the section? No, I haven't. Now I will again go and read it from the starting. But what I will do, I will implement the rule 6. What does rule 6 talks about? It talks about break the section in the in a smallest part, smallest independent part, which is self-explanatory or which gives the complete explanation without any other thing. For example, if I'm breaking this section for you and understand, where any check, this becomes your first aspect. What this particular talking about? Any check. Second, second part, drawn. Now, and I forgot to address one thing. The entire law or entire drafting of any particular act is based on logic. It follows one logical pattern. There's a what, why, how, when, where, and again it repeats. It then the flow repeats in the same way. For example, where any check. What it's talking about? Any check drawn. Why? What is talking about? It is addressing what? Where any check drawn. How it is done? Drawn by whom? By a person. So first part is where any check. Second part of this interpretation is drawn by whom? By a person on an account maintained by him. See, it is addressing WH question: what, when, where, which, whom, how, and why. Maintained by him with a banker for a payment of any amount or money to whom? To another person. From where this money will be going? From out of that account. Account of what? Account of whom? Which is maintained by the person who is drawing the check. Account for the discharge. So first part that we have broken this section is where any check. Second part, drawn by whom? By a person. Third, fourth part is broken into on an account maintained by him. Fifth part, with a banker. Sixth part, for a payment of any amount of money to another person. From seventh part, from out of that account. For eighth part, for discharge. Discharge of what? Or discharge in how it will be discharged? For the discharge. Ninth part, in whole or in a part of any debt or the other liability. So how many aspects this has covered? There is a drawer. There is a drawing. फर्स्ट पार्ट से क्या मालूम पड़ता है? देयर इज अ ड्रॉअर. सेकंड पार्ट से क्या मालूम पड़ता है? देयर इज अ ड्रॉइंग. थर्ड पार्ट से क्या मालूम पड़ता है? देयर इज अ पे. ये यहाँ पे क्या स्टैब्लिश हुआ? यहाँ पे स्टैब्लिश हुआ व्हाट दिस section is addressing to. There is it established a relationship between the three parties. Why this relationship was established? To discharge the debt either fully or partially, debt or any liability. Now we will move to, यहाँ पे लाइबिलिटी के लिए चेक दिया. अब चेक डिस्चार्ज के लिए गया, प्रेजेंटेशन प्रेजेंट हुआ. What will happen if it is written unpaid? Now it will break it into point number 9. Is returned by a bank. How? Unpaid. Why it is written unpaid? Either because of the amount of money standing standing to the credit of that account is insufficient to honor the check, or that it exceed the amount arranged to be paid from that account by an agreement made with the बैंक. तो यहाँ पे दो चीजें दो काइंड के it is existing two types of account. When it is talking about saving account, where you have to keep that actual money in your account. Let's say if I am giving you check of rupees 1 lakh, I need to keep at least 1 lakh of amount of money in my saving account or the current account. Now here it is talking about another kind of account, which is the current account, where there is a limit. Like for example, all of you have account with me. I am the bank, and I give you the limit of 1 lakh rupees, up to 1 lakh rupees. So whatever the if you are if the third party is presenting a check to me drawn on your account stating it's a 50,000 check, I will immediately clear whether your account has that 50,000 of money or not, because I have already assigned you a credit limit, and then you need to repay me back whenever within the due date. So it is talking about two kind of clearment process. Also, it is also talking about two kind of debt. One is actual debt, like I come to you to buy a product, you supply the product, and I need to pay you the money. This is a debt that occurs immediately. The other kind of debt is uh, credit, credit or line of credit, where you actually tell me, जिसको हम कहते हैं हिंदी में उधार लेना, कि यू कम आई कम टू यू कि मुझे आई वांट 100 iPhone या 100 iPads. You will say, okay, you can have 100 iPad, but your credit limit is 10 lakh rupees. So whatever up to the 10 lakh rupees, you can pay you can buy as many as iPhone you want, and you have to repay these repay up to the 1 lakh rupees within a month. That is my credit limit. If I go beyond that, I have to pay the amount immediately, or I have to clear the previous amount. Then my credit limit will be restored. Just like you do online shopping. The mode is called buy now pay later scheme. This is all the shopping is done on line of credit basis. So it's talking about two ways. So even if I am giving check towards the debt, actual debt or line on credit debt or any other liability, I am still be liable for section 138. Now they it talked about parties. It talked about why it talked about check. It talked about why it was drawn. It was drawn for discharge. Discharge of what? Liability, debt, and any other liability. Now after presentation, what happened? It was returned unpaid. So after going through, okay, we understood. It is talking about these three. Now what will happen if it return unpaid? Now the section talks about such person shall be deemed to have committed an offense and shall without prejudice to any other provisions of this act. यहाँ पे क्या क्या डीम कर दिया कि दिस पर्सन हैज कमिटेड एन ऑफेंस. चलो एक्ट हो गया, ऑफेंस हो गया. व्हाट्स नेक्स्ट? नाउ दिस सेक्शन टॉक्स अबाउट पनिशमेंट. Be punished with the imprisonment for a term which may extend to 2 years. Now there is an amendment in it, or with a fine which may extend to twice the amount of check, or with both. So after breaking down this entire section, I come to know there are the 7 to 8 essential points which I need to understand and which I need to keep in mind while drafting or while presenting this case before the court. Further, now there is a provision. What does provision talks about? Provision talks about like how If the second third party has committed an offense, how will you file this suit before the court, and what are the essential criteria? So again, you will read the provision and you will break it down. Provided that nothing contained is in this section shall apply unless, what is talking about, this provision, that nothing in this particular foregoing provision will apply until and unless I comply with these three things. What are these three things? First, the check has been presented to the bank. What is talking about? The check which was drawn earlier should be presented to the bank within a period of 3 months. Earlier it was 6 months, now it is 3 months. From the date on which it is drawn, मतलब जैसे आज ड्रॉ किया है मैंने, आज की डेट लिखी है, फ्रॉम द डेट ऑन विच इट इज ड्रॉन, आज मैंने ड्रॉ किया, तुमको चेक दिया, एंड यू वेंट टू द कोर्ट, वेंट टू द बैंक टुमारो एंड यू प्रेजेंटेड द चेक. It is drawn or within a period of 3 months or the time of its validity. So इसमें से जो भी पहले होगा, that check needs to be presented. अगर मैंने प्रेजेंट नहीं किया, तो will section 138 will be applicable? Absolutely not. Now the second aspect of provision talks about the payee. Who is the payee? One who is gonna get the money. Let's say if I have given you the check, you are the payee because I am the drawer. The bank is a drawee. You are the payee. The payee or the holder in due course of the check, as the case may be, makes the demand of the payment. Let's say I have given you the check and you have presented the check in the bank. So basically, you are making the demand for the payment of said amount by, and the check has been dishonored. When you have presented check to the bank, the check has been dishonored. After getting dishonored, you are making, or you are making the request to the drawer of the check for the payment, makes a demand for payment of the said amount of money by which method, by a notice in written to the drawer of the check within 15 days of the receipt of information. Which receipt of information? From the bank regarding the return of the check as unpaid. तो पहला चीज क्या बोलता है? द चेक हैज टू बी प्रेजेंटेड. दूसरा क्या बोलता है? देयर हैज टू बी रिटन नोटिस. रिटन नोटिस कब मिलनी चाहिए? आफ्टर द information or the bank receipt stating that the check has been dishonored. Within how many days? Within 15 days. इसके बाद क्या होता है? Then you give 15 days time. The drawer of such a check fails to make payment of the said amount. Who? The drawer of this check fails to make a payment of the said amount of money. To whom? To the payee, or as the case may be, to the holder in due course of the check. Within how many days? Within 15 days of the receipt of the said notice. So आज चेक बाउंस हुआ, कल मुझे बैंक से नोटिफिकेशन आया, 15 दिन के अंदर मैं नोटिस भेजा. सो लेट्स से मैंने फर्स्ट को नोटिस भेजा, 15 डेज के अंदर उसको मुझे पैसे देने. If the person has not given me the money within 15 days, this section becomes applicable. Now I have broken down this and big section into smaller part, because smaller individual part which gives the complete meaning, so as to understand what are the essential that I need to fulfill to invoke a particular section. Now there are few things which needs to be kept in mind while interpretation of a section. There are certain terms which are used frequently. So before going for their actual interpretation of the section, first you need to understand what does a particular word mean. For example, dishonor. So very first thing you go and find the meaning in the English dictionary. You find the normal English meaning, then you go and find the meaning in a legal dictionary. Sometimes uh, uh, a particular word has a normal different meaning in the English dictionary and a different meaning in a legal dictionary. Then then you go and find, does this particular word has been defined in this particular, let's say, this particular act or any other act or general causes act. What does the bare act definition of that particular word means? And then collectively you apply that definition in that particular section to interpret that particular section. Let's say here this we have to find that holder in due course. I think there is no such word holder in due course in English language. But however, Troy, section 9 of this act talks about holder in due course. Now you will read what does the holder in due course means, and then you apply that particular definition there. And following these 7 to 8 rules, you interpret a particular section there, and then you apply that section either in your arguments or either in your drafting or either in your research. This is this is a session on how to interpret a bare act and a section. Does anyone have any questions? If you have any more questions, please type it in the chat box. I presume you have understood this particular session on the interpretation of bare acts. Thank you, Nidhi, uh, for your feedback. And then, guys, that's for the day, and have a great day ahead. See you on the next section. Take care.